All right, today I'm going to talk to you about evidence. And I feel like I shouldn't have to say this, but if you want to make a point about anything in the law and you want to win any argument, you have to have the evidence to back it up. You want to win at trial, you got to have the evidence to meet your elements, right? And this is part of that foundation building. We need the evidence to build the foundation. We need to lay that foundation, and then we can apply the law on top of it and make our nice macaroni and cheese. Okay, so how do we get evidence, right? It's going to be in litigation, you're going to get it through discovery, and you're going to get it through, and that can be written discovery, depositions, subpoenaed documents, things like that. In response or in making any motion, you're going to need admissible evidence, right? You can't just be like, well, my sister's brother's dog said that, whatever, like it can't be hearsay. It's got to be factual. It's got to be evidence that the court can actually rely on. Okay, so every motion you write, every motion you oppose, you're going to have evidence, and almost always that comes in the form of an attorney declaration. That's how the evidence is authenticated, and I'm going to have a whole separate video on writing the attorney declaration. No matter what you do, you've got to have a body of evidence, and the body of evidence for each kind of motion is different, right? So for like a demur or a motion to dismiss in the rest of the country, not California, your evidence is not going to be extrinsic evidence. It's going to be the complaint, and it's going to be meet and confer efforts between the parties, and it's going to be anything like that you can judicially notice, like court records and things like that. So it's a very small body of evidence, but that's the evidence that you rely on. For a motion to compel discovery, you're going to need the discovery requests, you're going to need the discovery responses, you're going to need meet and confer letters and correspondence and emails and conversations and whatever you've got. And those are the things that make up the body of evidence for that. If you're going to be working on a dispositive motion, like a summary judgment or a judgment on the pleadings or something like that, you're going to need more evidence of the kind that would be introduced at trial. You're going to need testimony, you're going to need documents and things like that. So whatever you need, you're going to have to gather it all together, and you're going to need to know what it all says. It's not enough to say, here's a document, go look at it. You have to pull out phrases, paragraphs, information from that evidence to cite to in your brief, in your statement of facts, in your separate statements, things like that. So it's not enough to just have the document and tell the court to go look at it. That's never going to fly. The court is not going to like that, and they're going to say, no, you had your chance, you didn't make a case. So this is part of laying your foundation. You can't just say, I win because of this document. You have to say, I win because this document says these 4 things that prove this specific element, and they prove this specific element because, and then you do your analysis. It's not enough to say, I win, check it out. So, okay, how do I do it? I've developed over the years a thing that I call my evidence worksheet. It's very simple, it's very rustic, and it's just a Word document that's got a table for every deposition summary, or the bits and pieces of the deposition that I'm going to pull out that are important to whatever motion I'm writing. It's got a table for each set of discovery responses, and especially in California, they're made under oath. I'm not sure about the rest of the country, but they're made under oath, so they're the same, they carry the same weight and admissibility as any deposition testimony, right? It's you could be used, you can trust that it's under oath under the penalty of perjury. So I have a table for each deposition, a table for each discovery response, and then when I'm talking about request for production responses, documents produced in response to a request for production, I'm going to have a heading. It's probably not a table, it's a heading for each of those documents as well. And then I'm going to go through the documents, and I'm going to read, and I'm going to say, on page 2 it says this, on page 4 under paragraph 27 it says Y. So I'm going to go through all that. If there's physical evidence, photographs, things like that, I'm going to write a description of what's in them, and I'm going to put it all together. And then that's going to be my go-to document. That's going to be my document that is a summary of all the evidence I have that I think is relevant to the discussion inside the motion that I'm writing or opposing. I cannot stress enough how important it is to read every single page of every document you're going to submit to the court. First of all, you don't want to be surprised when the court's like, well, hey, I was bored this week and I decided to read every page of that document that you submitted, and did you know that on page 328 there's a clause that like makes you absolutely lose? I mean, you got to know your evidence so you can make valid legal arguments, right? But beyond that, it's the best place to get those nuggets that are going to lay that foundation from which you cannot fall. If you've got a solid foundation of facts and evidence, then you've got a place that's not just a sandy beach that's a little bit rocky. You've got a solid concrete situation where you're on solid ground. You're going to be able to carry the day. The more facts, the stronger your foundation, and the more chance of winning, okay? Don't do the "this is why I'm hot" thing. Okay. Oh, so at the bottom of my evidence worksheet, I will do a list of exhibits that I'm going to attach to my brief. So I'm going to say, okay, there's evidence from this deposition that I think is important to the discussion. And so that deposition transcript has to be an item of evidence, and I'm going to write that as Exhibit A. And I'm going to make that my Exhibit A, and that way I know from the very beginning, before I even start writing, what exhibit it is, and later when I talk about it, I can easily and quickly cite to it. And if it's a discovery response and I want to say, hey, this document was produced in response to request for production set 1, question number 22, and as whatever exhibit, and I'm going to attach it to my brief as Exhibit B. And now I know every time I talk about that request for production and document, it's going to be Exhibit B. All right, so, and I'm going to make that list at the bottom of my evidence worksheet. Sometimes I move that to the top so it's easier to find, but regardless, I'm going to make that list of all the exhibits I think I'm going to need at the very beginning, before I start writing a declaration, before I start writing the brief at all. I'm going to have my exhibits lined up, and I'm going to have them, you know, I'm going to create the PDF forms or the PDF files that are those exhibits. I'm going to put a Exhibit A cover page right on it from the very beginning, and then it's ready to go at the end. And that's part of assembling the evidence at the beginning. I'm just going to repeat what I just said. From the beginning, while I'm going through my evidence, this is first step of in the order of operations is, of course, knowing where you're going. So I've done that step. Step 2 in the order of operations is knowing my evidence and facts. So 2A is evidence. All right, so now we've got our exhibits all gathered together and our evidence summarized into a nice handy worksheet that we can copy and paste from for the rest of for the time that we're writing our brief, okay? So I'm going to now stop, and I'm going to do a separate video with a Loom video where you could like see the actual evidence worksheet and how I use it in brief writing. And then we'll move on to knowing your facts, which is order of operations 2B. Okay, bye.